Everyone here knows the truth. You just water the plants.
Come on, sis. You know you can't win this.
Sign it before Monday, or I call the state.
Starting tonight, you deal with me.
That Tuesday evening, the folder already had Clara's name printed plainly across the tab, and nobody in that room yet knew he had been holding it since before he ever knocked at the gate. Clara left without another word, her boots loud against the concrete path between the propane tanks and the gate, and the sound of her car door did not carry the satisfaction she had clearly intended it to. Nolan followed a few steps behind her, already typing something into his phone before he reached the car. Nia did not sit down right away. She walked the length of the growing tables, first checking the humidity gauge above the seed trays out of habit rather than need and only. When she reached the far bench, did her hands finally stop moving. June did not follow her down the row. He left through the same gate he had entered, the folder still under his arm, without asking her a single question about the quitclaim or what Clara had threatened her with. Neither of them spoke again that night. Nia locked the propane valve, folded the unsigned quitclaim into the drawer beneath the potting bench where she kept her grandmother's old seed catalogs, and photographed both pages of it on her phone before she closed the drawer. A habit she had picked up 11 months earlier and had never once needed until now. By 7 the next morning, she had left a message for Deborah Okafor, the attorney who had handled her father's estate filings without charging her $1 for it, asking for 30 minutes whenever Deborah had them. Deborah called back before Nia had finished her coffee. 38 years old, 7 years into a mostly solo practice on the second floor, above a dry cleaner on the south side, and the only person in Nia's life who had read every page of her father's trust documents twice. June had opened the file on Clara 3 weeks before he ever drove out to that greenhouse after a routine compliance flag connected her name as trust executor to a parcel that still carried an old, mostly forgotten lien from 20 years earlier. 20 years earlier, a man named Marcus Carter had borrowed $38,400 from James Co. to keep a half-acre parcel and the seed stock growing on it out of a forced sale at a time when nobody in either family thought the two men would ever meet again after the closing. The land was the only thing of value Marcus's own mother had left him, and the seed stock on it a strain his wife's mother. Odessa had bred over 11 growing seasons was worth nothing to a bank appraiser and everything to the two families who understood what it could become. James Co. had structured the loan with a single unusual clause, one his own lawyers had argued against at the time. If the collateral parcel was ever transferred, assigned, or licensed without the lien holder's written consent, the full remaining balance came due immediately, and the lien holder retained the right to freeze any pending transaction touching that parcel until the balance was resolved. Marcus paid the loan down for 11 years without missing a payment, and by the time he married Clara 9 years ago, the balance stood at $4,150, a number small enough that he stopped mentioning it to anyone, including his own daughter, believing it would be settled long before it ever mattered to her. It was not settled. Marcus died 14 months ago of a heart condition nobody had caught in time, and the $4,150 sat quietly in a filing cabinet at CO Capital Partners, attached to a name nobody there had thought to connect to anything happening now until Clara's own name pulled it back into the light. Nia's own work had nothing to do with any of this, or so she had believed for most of her adult life. She had spent 6 years learning to isolate and stabilize Indigo naturalis, a compound drawn from indigo family plants that dermatology researchers had studied for decades as a topical treatment for chronic plaque psoriasis. Not a cure, never a cure, but a reduction in inflammation, strong enough to change what a bad flare looked like on a child's arms and knees. Odessa's strain of midnight indigo carried a concentration of the active compound, nearly double what commercial growers achieved. Something Nia had confirmed 3 separate times, using equipment she had bought secondhand from a university surplus auction, because a commercial lab test cost more than she could justify spending twice. On Tuesday and Thursday evenings, she ran a clinic out of the same greenhouse, unpaid, for families whose children had been turned down for biologic drug coverage or did not qualify for the pharmaceutical company's compassionate use programs, families who arrived with insurance denial letters folded into their coat pockets and left with a jar of salve and instructions written in her own handwriting. She kept a ledger of her own for the clinic, separate from her grandmother's seed catalogs, a spiral notebook where she logged each child's weight, the percentage of body surface affected, and the concentration of the batch she had given them, because a commercial lab would have wanted exactly that data before taking her seriously, and she intended to be ready the day one finally asked. 19 families were on the list that winter. Most of them referred by word of mouth rather than by either dermatology practice, and 11 of the 19 had a child under the age of 10. Nia kept a small paper map of the city tacked to the wall near the drawer, a pin for each family's neighborhood. A habit she had started less to track logistics than to remind herself on the nights the work felt endless. Exactly how far people were willing to travel for a jar of salve that cost her almost nothing to make and cost them nothing at all to receive. Priya Nair, a 19-year-old chemistry major, 2 years into a program that would not let her near a real laboratory bench until her senior spring, had found the clinic through a flyer at a community health fair and had shown up every Tuesday for 8 months, since first to observe, then to measure, then by the fall trusted to run a batch through the centrifuge on her own while Nia handled patients. Nia paid her nothing and offered her something she valued more, a signed letter for her transcript file, confirming 310 hours of applied laboratory experience, a number Priya had started counting from the very first Tuesday. Marcus had never once explained the loan to Nia while he was alive, not because he was ashamed of it, but because the two men who arranged it, his and June's father, both had agreed at the closing table 20 years earlier that the debt belonged to the land, not to either of their children, and that neither family had any obligation to carry the weight of it forward once it was paid. James Co. had liked Marcus in the brief formal way. Two men from very different worlds sometimes like each other across a closing table, enough to structure the loan at a rate 2 points below what his own firm's underwriting guidelines allowed, a fact that had never appeared on any document either family kept. She had met June once before a year earlier, though neither of them had thought much of it at the time. He had come to the greenhouse as part of a routine portfolio review, the kind SEO Capital ran on every collateral property in its books once a year, and he had spent 40 minutes watching Nia recalibrate a pH meter without once looking up to acknowledge him. He had not been impressed by the greenhouse, or by the fact that a woman was running it alone, or by anything he could have written down in a report. He had been impressed by the fact that she recalibrated the meter 3 times before trusting the reading, checking it against a second instrument each time. The exact habit his own research director back at the firm had spent years trying to drill into junior analysts who cut corners. He had left that first visit without introducing himself by his full name, listed on the review as JCO Collections Division, and had not thought about the greenhouse again until Clara Carter's name surfaced 3 weeks later in a routine compliance flag tied to that same half-acre parcel. Nia had noticed him too, though she would not have admitted it to anyone that year, mostly because he was the only visitor the greenhouse had ever had who asked no questions about her credentials, her funding, or why a black woman was running an unlicensed extraction operation out of a converted greenhouse instead of a proper lab. He had asked one question that day, and only one: what happened to a batch if the humidity dropped below 40% overnight, and he had listened to her full answer without checking his phone once. Sunhee, a paralegal in the same office, was the one who pulled the original 1996 note from deep storage. Once June flagged the name, and it took her less than an hour to confirm what he had already begun to suspect: the greenhouse from his own portfolio review a year earlier, and the parcel now tied to Clara's compliance flag were the same half-acre lot, filed under 2 different names, by 2 men who had never imagined either daughter would need to know the other existed. Clara learned about the clinic's value from Nolan, who had learned it from a colleague in Haniel Group's business development office, the same office that had spent the last 4 months quietly evaluating independent formulations for licensing before a wider acquisition search. The colleague had mentioned almost in passing that a woman on the South Side was running an unlicensed indigo naturalis operation, strong enough that 2 dermatology practices had started referring patients to her directly, and that Haniel's chemistry team wanted a formal introduction before a competitor found her first. Nolan had not connected the name at first, assuming it was a coincidence, until his colleague mentioned the address, a half-acre parcel on the south side with a converted greenhouse structure. The same parcel he had visited a dozen times as a teenager for Sunday dinners before his mother married Marcus, back when the greenhouse still held nothing but his stepfather's tomato plants and a rusted set of lawn chairs, and he had never once thought to look closely at what had replaced them since. It was Nolan who suggested going out there together that same week, telling his mother only that the family needed to settle the land question before it settled itself without them, and it was Nolan standing near the propane tanks that evening who watched the rows of deep purple-leafed plants he did not recognize and understood for the first time exactly what he was looking at. Nolan understood immediately what his mother did not yet grasp. The greenhouse was not a sentimental inconvenience standing in the way of selling a half-acre lot. It was the asset. He had spent enough time in Haniel's business development meetings to know how licensing valuations worked, and when he ran the numbers himself, using a spreadsheet template from work, a formulation with double the standard, active compound concentration, already validated by 2 dermatology practices, priced out well above what the underlying land alone was worth. A fact he did not share with his mother right away, choosing instead to let her keep believing the leverage was the land itself. Clara had grown up believing that family money moved through wills and deeds, not through licensing agreements and patent assignments. And it took Nolan 3 separate conversations over 2 weeks to convince her that pushing Nia to sign over the land would accomplish nothing if the formulation itself stayed in Nia's name. She asked him the second time whether what he was describing was even legal, and he told her the assignment only needed a signature and a notary stamp, both of which he could arrange himself without troubling her further. A sentence she chose to hear as reassurance rather than as the warning it should have been. Clara's authority as executor of the family trust granted, while Marcus's estate remained unsettled in probate, allowed her to sign transfers on trust property without Nia's separate consent. A power she had never once needed to test, because Nia had never given her a reason to. The trust document itself, drafted 11 years earlier by a different attorney than Deborah, listed the greenhouse structure and the land beneath it as trust property, but was silent on any formulation patent or intellectual property developed on that land after the document was signed, a gap neither Clara's attorney nor Nolan noticed until much later, and one Deborah would eventually build an entire argument around. Clara signed a cover letter authorizing Nolan to handle the paperwork on her behalf, a single vague sentence she dictated to him over the phone one evening while distracted by a pot on the stove, never once asking to see the document itself before it went out. A fact her own attorney would later call the single worst decision she made in the entire matter. Nolan drafted a formulation licensing assignment over a single weekend using a template his business development colleague had forwarded him, and he signed Nia's name to it himself, copying her signature from an old grant application she had once left visible on the kitchen counter. He practiced the signature 4 times on a legal pad before committing it to the actual document, comparing each attempt against the grant application under the kitchen light, and he was satisfied enough with the 4th attempt that he did not bother with a 5th. He accessed Nia's shared research drive, using a login she had granted him 2 years earlier for a single afternoon of unrelated grant paperwork. Neither of them had ever formally closed out, and he used that same session at 2:14 in the morning on a Sunday when he could not sleep to draft the assignment document itself directly inside her account. He notarized it through a mobile notary service that verified identity by driver's license photo rather than in-person appearance. A service he had used twice before for unrelated paperwork and knew asked no questions past the fee. The notary's system flagged nothing, charged $45 to Nolan's card, and emailed a stamped PDF back within 11 minutes. The assignment reached Haniel's legal department on a Friday morning, and by Monday, a congratulatory email had gone out internally announcing that the Midnight Indigo formulation was cleared for the merger track, $4,683,150, pending final signature at a signing scheduled for the last week of the month. The email listed Nolan as the family's internal point of contact for logistics, a detail 3 separate Haniel employees would later confirm to investigators without hesitation, since none of them had thought at the time that there was anything to hide. One of those employees, a junior chemist who had spent 6 weeks corresponding by email with someone she believed to be Nia about extraction batch specifications, had in fact been corresponding with Nolan the entire time, a detail that would surface only when investigators compared her email thread against the login records Deborah had subpoenaed. Nia found out on a Tuesday afternoon when a Haniel account representative called to confirm delivery logistics for a shipment she had never agreed to send. She did not raise her voice on the call. She asked the representative to repeat the contract number twice, wrote it down, thanked him, and hung up before he could ask why she sounded confused rather than pleased. She sat at her kitchen table for 11 minutes after hanging up the contract number in front of her on a scrap of paper before she picked the phone back up and called Deborah instead of calling Clara, a decision she would later describe to Deborah as the only clear-headed thing she remembered doing that entire day. For 3 days after that call, Nia said nothing to anyone outside of Deborah's office. She requested her own bank's time-stamped record of every login to her research files for the past 6 weeks, pulled her grandmother's old ledger to cross-check every batch number against the dates Haniel claimed she had certified, and asked Deborah to formally request a certified copy of the notarized assignment from Haniel's legal department. She kept a running list on a single index card taped inside the cover of her Spiral Clinic notebook, where Priya would never think to look 3 columns, only what she knew, what she could prove, and what she was still missing. And by the end of the first week, the third column was longer than the other 2 combined. She did not tell Priya any of it, and she did not cancel a single Tuesday or Thursday clinic shift, seeing all 19 families on schedule that month, because the one thing Clara had never understood about her stepdaughter was that Nia treated a crisis the same way she treated an unstable batch, by isolating the variable and continuing the routine around it, rather than letting the routine collapse. Deborah, working the same problem from the legal side, requested the notary service's full transaction log for the date in question, rather than just the single-stamped document, a routine step most people forget to take, and one that would matter more than either of them understood at the time it was filed. The copy arrived 9 days later. Deborah noticed the discrepancy before Nia did. The notary stamp on the assignment was dated 2 full days before the confrontation at the greenhouse. 2 full days before Clara had ever demanded a signature from Nia in person, meaning the document Nolan filed had been prepared and notarized before his mother had even made her threat, not after. Deborah read the date 3 times before she called Nia, because a mistake like that, a notary stamp dated ahead of the event, it supposedly followed, was not the kind of error a careful forger made. It was the kind of error a confident one made, someone who had never once considered that anybody would check the sequence closely enough to notice. Whatever Clara believed she was negotiating for at the greenhouse gate, the outcome had already been decided somewhere else entirely on paper in advance, which meant the 30-second countdown Clara had given her that night had never been a real choice at all. Only theater staged for a decision already made 2 days earlier without her. Clara moved forward publicly 2 weeks later, when Haniel's public relations office issued a short statement crediting the Midnight Indigo formulation to, in the company's words, family stewardship, spanning 3 generations, a phrase Clara herself had suggested during a call with Haniel's counsel, one that mentioned Odessa by name but not Nia once. The statement ran 4 sentences and included a stock photograph of an unrelated greenhouse licensed for $200 from an image library, because nobody at Haniel had thought to ask Clara for a photograph of the real one. The statement circulated among the 2 dermatology practices that referred patients to Nia's clinic, and one of the practice managers, a woman Nia had worked with for 4 years, called to ask not unkindly whether Nia still had any involvement with the formula at all, or whether the family had simply been letting her run the greenhouse as caretaker labor while the real ownership sat elsewhere. Clara's sister called Nia directly that week, saying she had seen the press release and wanted to make sure there were no hard feelings. A call. Nia let go to voicemail and did not return, not out of anger, but because she had learned over the preceding month exactly which family members were worth spending her limited energy explaining herself to. An old family friend of Odessa's, a retired nurse named Corinne, who had known Nia since she was 6 years old and still stopped by the greenhouse most Sundays with a thermos of coffee, was the one person outside Deborah's office. Nia did tell everything to sitting on an overturned crate near the propane tanks one evening while Corinne listened without interrupting once. Nia answered the question, the same way she had answered the account representative calmly, and hung up the phone with her hands steady. And it was the first night in 3 weeks that she did not sleep more than 2 hours straight. She lay awake doing arithmetic of her own, not about money, but about the 11 weeks on the clinic waiting list. And what would happen to that list if a company that had never once asked her name decided it owned what she made? Clara, for her part, believed the matter was already settled and told her sister on the phone that week that Nia would come around once she understood there was more money in cooperating than in holding a grudge over paperwork. A sentence her sister would later repeat almost word for word to a courtroom that had stopped finding it convincing. Nobody in either family yet knew that the notary's automated system, the same one that had approved Nolan's forged signature in 11 minutes, retained a server log of every document. It processed time-stamped to the second, a detail that would not matter to anyone until Deborah's subpoena reached it 4 months later. June learned about the forged assignment the same week. Son, he confirmed the lien connection, though, from an entirely different direction. SEO Capital's compliance division flagged any transaction involving a property with an active lien, automatically a routine safeguard that had triggered exactly 4 times in the firm's history and had never once resulted in anything more than a paperwork correction until now. The flag reached June's desk on a Monday morning, a single line in a compliance queue listing a pending merger transaction touching a parcel still carrying an active 1996 note, and it took him 11 minutes at his desk to connect the parcel number to the same address on the greenhouse portfolio review from a year earlier. He pulled the original review file first, the one he had written himself, and reread his own year-old notes on the visit, 3 lines only describing the greenhouse's condition as well-maintained, and the operator as methodical notes he had written without any idea they would matter again. He read the compliance flag twice before he understood what it meant, and a third time before he let himself consider what it might require him to do. He said nothing to Nia. I did not call the greenhouse, did not send a message through Deborah, did not appear at the clinic on a Tuesday evening under any pretense, because the one thing he understood clearly from watching her recalibrate that pH meter a year earlier was that she had built the entire operation herself without asking permission from anyone, and he had no intention of being the man who decided without being asked that she needed rescuing. Instead, he read the original loan file 3 times, confirmed the change of control clause his own father had insisted on, 20 years earlier still held, and had CO Capital's outside counsel prepare formal notice invoking it. The clause was unambiguous. Any transfer, assignment, or license of the collateral parcel without the lien holder's written consent triggered immediate repayment of the remaining balance, and gave the lien holder standing to freeze the pending transaction until the matter was resolved through the courts. The remaining balance, $4,150, was not the leverage. The freeze was. June filed the notice with the Cook County Recorder's Office on a Wednesday, a filing that took 11 days to formally register and required 3 separate supporting documents: the original 1996 note, the current title search, and a sworn declaration that no consent had been given for the pending Haniel transaction. CO Capital's outside counsel, a firm that had handled the note's original drafting 20 years earlier, billed 19 hours preparing the 3 documents, cross-checking every figure against the original closing file before letting June sign the sworn declaration. It was for the first time in 20 years, publicly on record, that James C.O.'s son now held and controlled the collateral note, a fact that reached Clara's own attorney 3 days after the filing registered, though it would not reach Clara herself for another week. How was James C.O.'s only son, and by every expectation attached to that fact, he should have taken control of CO Capital the week his father died 3 years earlier, the way his father had taken control from his own father and his grandfather before that. He had refused, not out of resentment, but because he had watched his father run the firm as a name first and a person second for 30 years, greeted at every function by his title before anyone asked how he was doing, and June had wanted for at least a while to know what his own judgment was worth, without the name attached to it. For 3 years, he worked the collections desk under initials only, JCO reviewing files, nobody senior wanted, while his mother, still living in the house outside Seoul where he had grown up, kept marking his birthday, the same way she always had a bowl of seaweed soup, made the traditional way, regardless of whether he was home to eat it, and a plain white envelope of cash mailed to whatever address he currently used. He kept both of his father's photographs, the one from the office and the one from the house, on a low shelf near his desk, rather than a wall close enough to see, not so visible that anyone visiting would ask about them. Sun Hee, the paralegal who had first confirmed the lien connection, kept a photograph of her own grandfather on her desk, in the same modest way, and she was the one who noticed months later that June had started keeping his father's photograph slightly closer to the front of the shelf than before, though neither of them ever mentioned it directly. His mother had never once told him to come home and take his father's seat, not directly, but she folded a newspaper clipping about CO Capital's quarterly results into every envelope she mailed him, for a full year after the funeral, without a single word of commentary attached, until he asked her on a call one Sunday to please stop, and she did, and neither of them mentioned it again. He had a younger sister married to a surgeon in Busan who had inherited none of the pressure attached to the family name, and had told him once, the only time either of them discussed it directly, that she envied him nothing about being the son, except how loudly everyone assumed he wanted the job. This case was the reason he finally stopped hiding behind the initials. Not because Nia needed him to, but because the moment he read his father's clause and understood what it could do, he understood there was no version of using it quietly under a fake title that would hold up if Clara's attorneys challenged his standing in court, and standing required his real name on the filing. The first call was to the equipment supplier Nia used for her extraction work, quietly settling an overdue lease balance on her centrifuge that she had fallen 3 months behind on, without telling anyone, structured as a routine account correction, so it would never trace back to a name, a total of $620. The supplier's billing system logged simply as an adjustment, no memo attached. The second was to a customs broker he knew from an unrelated deal, clearing a shipment of lab reagents that had been held up at the port for 6 days over a paperwork error, the exact reagents Nia's assistant had been calling about twice a day without success. Nia's assistant, a 19-year-old chemistry student named Priya, who worked Tuesday and Thursday clinic shifts for course credit, noticed both corrections within the same week and mentioned them to Nia only in passing, assuming they were simple billing fixes, and Nia did not think to ask who had made either call. It was Nia herself who found the piece that mattered most working with Deborah, rather than waiting for anyone else to hand it to her. She spent 2 full evenings after clinic hours going through 6 weeks of her own drive access history line by line looking for any login. She could not immediately explain cross-referencing each one against her own calendar and Priya's clinic schedule until only a single entry remained unaccounted for. Deborah had subpoenaed the metadata log from the cloud storage account, where Nolan had drafted the forged assignment, and the timestamp on file creation, read 2:14 in the morning, 3 weeks before the notary date on the document itself, accessed from a device still logged into Nia's own shared research drive under a login Nolan had never had revoked. Nia remembered granting that access. She remembered exactly why she had back when Nolan had offered unprompted to help her format a grant proposal's budget section, one of perhaps 3 genuinely kind things he had ever done for her, and she remembered exactly how long ago she should have removed the login and simply never had, and the fact that she had not was the only piece of this entire mess she was willing to call her own mistake. Deborah told her when she said as much out loud that leaving a door unlocked did not make a person responsible for who chose to walk through it. Uninvited, and Nia did not fully believe her, though she stopped saying it out loud after that conversation. Sun Hee traced the handwriting to Marcus Carter's own hand, comparing it against a payment history card in the original loan file, and found that Marcus had mailed a full update of his own loan documentation directly to CO Capital 18 months before he died, along with a letter still in the file stating his intention to pay the remaining balance in full within the year, and asking that the note be marked. Satisfied, once he did so, his daughter would never have reason to know it had existed at all. He had written Clara's name on the folder tab himself from memory, the only time he had ever needed to write it, rather than simply speak it, and he had gotten it wrong. He never got the chance to finish paying it off. June understood reading that letter that Marcus had spent the last 18 months of his life trying to erase a debt his own daughter didn't know existed to protect her from exactly the kind of leverage Clara was now trying to use, and that the debt Marcus had failed to finish paying was the same debt that would end up freezing Clara's transaction 2 years later. The signing was scheduled for the 31st floor of the Ashford Meridian Hotel, a conference room Haniel had used for 4 previous acquisition closings, with floor-to-ceiling windows facing the lake and a long walnut table set for 11 signatories and their counsel. Deborah had spent the 2 weeks leading up to the date coordinating quietly with Ford's office, timing the search warrant and the civil freeze petition to both clear the same afternoon Haniel had already scheduled for signature. The warrant itself had taken 19 days to assemble properly, built on the metadata log, the loan documentation, and a sworn statement from Nia describing the greenhouse confrontation in detail, reviewed twice by a judge before it was signed. Nia arrived with Deborah at her side, in the same coat she had worn to her father's funeral 14 months earlier, and took a seat near the middle of the table rather than the head of it. A placement her attorney had chosen deliberately close enough to see everything far enough to not be mistaken for the one on trial. Clara arrived 20 minutes early, in a coat she had bought specifically for the occasion, and took the seat closest to the head of the table before anyone could suggest otherwise. She had spent the 2 weeks since the freeze notice reached her attorney, convinced it was a procedural nuisance, a small balance from a note she genuinely believed her late husband had settled years earlier. She had brought a folder of her own to the table that morning, thinner than the one Ford would eventually set down, containing only the Haniel term sheet and a printed copy of the family stewardship press release. The caterers finished setting the last of the water glasses, just as the wall clock read 2 minutes to the scheduled start, and for those 2 minutes, the room held the particular quiet of 11 people waiting for a formality they each expected to take less than an hour. She told the room, while the caterers were still setting water glasses, that she considered the whole matter beneath discussion. A family footnote that had nothing to do with the value her late husband's daughter had inherited the sense to protect, and that she expected the signing to proceed on schedule. Nolan sat 2 seats down from her, checking his phone under the table. Confident enough in the notary's stamp, he had arranged that he had not once considered what a subpoenaed metadata log might say about the hour it was actually created. At 8 minutes past the scheduled start, Detective Renata Ford entered the room with 2 officers from the Financial Crimes Unit, along with Deborah Okafor and a forensic document examiner carrying a single pale green folder. Ford set the folder on the table, squared its corners against the walnut surface, and turned it so the tab faced the room before she said anything at all. June had not come to speak. He had come to sit at the far end of the table in a seat that put James C.O.'s name printed clearly on the recorder's filing, now stacked beside Ford's folder directly across from Clara's, for the first time since either family had heard of the other. I had not told Nia he would be there, and when she saw him take the seat, she understood in the span of a single breath more of what had happened over the past 3 months than anyone in the room had yet said out loud. She did not smile at him, and he did not nod at her, both of them understanding without a word passing between them. That anything read as familiarity in this particular room would only give Clara's attorney something to argue about later. The room fell quiet again once Ford and her party had taken their places, the kind of quiet that settles over a room full of people who have each independently started doing arithmetic they had not expected to need that morning. The examiner, a woman named Priscilla Ang, who had testified in federal court 11 times over a 14-year career, walked the room through 3 pieces of evidence in order, without raising her voice above the volume of someone reading a weather report. First, the metadata log showing the licensing assignment had been created at 2:14 in the morning, 3 weeks before its notary stamp claimed from a device logged into Nia's own research account under credentials that had never been formally authorized for that use. Second, the original 1996 loan documents, alongside Marcus Carter's own letter describing his intent to pay the balance in full and his request that the note be marked satisfied, and Ong read the letter's closing line aloud, the one where Marcus asked that his daughter never have reason to know the debt existed at all. Third, a set of internal Haniel emails obtained through subpoena, in which Clara's own attorney had suggested the family stewardship framing to Haniel's public relations team a full 9 days before the assignment was ever filed. Ang printed a single line from that email chain onto a handout. She passed down the table a sentence in which Clara's attorney had written that the framing would keep the daughter's name out of the story entirely, a phrase that landed in the room heavier than any of the numbers that came before it. Clara's attorney tried to speak twice during the presentation, and both times Ford asked him without raising her voice to hold his objections until the examiner had finished. Aang closed her presentation with a fourth item, the notary service's full transaction log showing the document had been processed at 4:17 in the morning, a timestamp that lined up to the minute with a login on Nolan's own personal laptop rather than any device belonging to Nia. One of the Haniel representatives seated near the window asked quietly whether the company's own legal team had reviewed the assignment before accepting it. Nobody in the room asked Clara to explain herself before Ford spoke again. "It was never yours to keep." Ford read the line back exactly as it had been recorded 3 months earlier, letter for letter from a statement Nia had given Deborah's office the week after the greenhouse gate. The room did not move for the length of time it takes to set down a folder, and the silence that followed was not agreement, but arithmetic. Everyone at the table finally doing the sum Clara had spent months avoiding. Ford read Nolan his rights first for fraud in the making of a false instrument and unauthorized computer access, and the metal of the cuffs made a small ordinary sound against the walnut table that nobody at that table would ever describe as satisfying, only as final. Nolan did not resist and did not speak, and the last thing he did before the officers walked him out was look toward his mother, who was not looking back at him, her attention already fixed on her own attorney. The Haniel General Counsel quietly instructed his associate to begin drafting a formal rescission of the entire licensing track. Clara was not arrested that afternoon. Her face did not change in any way the room could name, though the coat she had chosen so carefully that morning seemed in the space of that single sentence to fit her differently than it had an hour earlier. Her attorney requested a brief recess before Ford could finish explaining the second filing a civil petition freezing her authority as trust executor, pending a full accounting of the family trust's assets, effective immediately by court order already signed that morning. By the time the recess ended, the Haniel representatives had quietly left the room, gathering their folders without a word to anyone still seated, and the $4,683,150 signing did not happen that day. Clara's attorney spent the recess on the phone in the hallway, and when he returned he told Clara only that the civil freeze would hold for now, that fighting it in the next 30 days would cost more in legal fees than the trust likely had left to spend. Clara did not look at Nia again before she left the room, though she paused near the doorway long enough that everyone still seated understood she had considered saying something and decided against it. Nia stayed in her seat until the room had mostly emptied, and it was Deborah, not June, who finally touched her shoulder and told her it was over, at least the part of it that happened in this room. June waited by the elevator bank rather than approaching the table directly, and when Nia reached him, neither of them spoke about the note, the clause, or the year he had spent under 2 initials instead of his full name. He asked her whether the greenhouse's heating system had held up through the cold snap that week, and she told him it had. 4 months later, in a courtroom in Cook County, rather than a hotel conference room, Nolan Carter accepted a plea agreement on the fraud and unauthorized access charges and was sentenced to 42 months in state prison. The plea agreement required Nolan to admit on the record that the assignment had been drafted and notarized before Clara's confrontation at the greenhouse, and the prosecutor read that admission aloud in full before the judge accepted the plea. Clara's authority over the family trust was permanently revoked by the same court, and she was ordered to personally repay $61,280 back into an account earmarked for the greenhouse's operating costs. A separate civil accounting filed the same week found that Clara had also directed $11,000 from the trust toward her own attorney's retainer. In the months leading up to the signing, a sum the court ordered returned as well. Nia did not attend either hearing in person. She sent Deborah in her place and spent both mornings in the greenhouse, instead running a batch of midnight indigo extract through the same second-hand equipment she had bought at a university surplus auction, checking the concentration 3 separate times before trusting the reading. She filed for formal registration of the midnight indigo formulation under her own name that same month, the first time in the plant's history that any single person had held clear, undisputed ownership of it on paper. So began a new licensing conversation with Haniel's chemistry team, directly on terms. Her own attorney negotiated line by line with a royalty structure that funded the free clinic hours permanently rather than depending on whatever Nia could spare after rent. Two dermatology practices that had briefly doubted her sent formal referral agreements within the month, both including this time. A line explicitly crediting Dr. Nia Carter's formulation, and the practice manager who had called with the uncomfortable question during the hardest week called again this time to apologize. And Nia told her there was nothing to apologize for and meant it. The clinic itself did not slow down. Priya took on a second shift, a dermatology resident, from one of the referring practices, started volunteering one Thursday a month, and the waiting list, which had once stretched to 11 weeks, settled into something closer to 2. The greenhouse itself changed very little that spring. The same growing tables, the same humidity gauge. Nia still checked out of habit rather than need, though a new sign now hung by the door alongside the clinic hours, small and hand-lettered like the first one listing the formulation's registration number for anyone who asked. Odessa's original seed catalogs stayed exactly where they had always been in the drawer beneath the potting bench, though the drawer itself had a lock on it now. Nia installed herself on a Saturday afternoon with a hardware store kit and no help from anyone. Corinne still came by most Sundays with her thermos of coffee, and that spring she started bringing a second thermos too, without ever announcing why, until the week Nia finally asked. And Corinne told her it was for whichever of the clinic families happened to still be waiting when she arrived. Priya, in her final semester, now submitted Nia's signed letter, along with 310 logged hours, to her program's laboratory placement committee, and was accepted into a formal research assistantship. The following fall, a fact, she told Nia in the greenhouse on a Tuesday evening, both of them too busy running a batch to stop and mark the moment properly. Priya asked before she left that evening whether Nia would ever consider hiring a second assistant now that the licensing money had started coming in, and Nia told her she already had someone in mind. On a Sunday in late spring, Nia found June at the greenhouse gate without an appointment, holding nothing but a small white envelope, which he explained when she asked was meant for the clinic's supply fund, rather than for her, and which he asked her not to mention had come from him at all. She did not open it in front of him. She set it on the potting bench in the exact spot where a pale green folder had once sat, squared its corners against the wood, and told him she would think about it, which both of them understood to mean yes. He had taken his father's title formally by then, listed on CO Capital's letterhead under his full name for the first time in 3 years, and the first decision he made under that title before any other was to formally satisfy the remaining $4,150 balance on the note his father had written 20 years earlier, marking it closed the way Marcus had asked. I did not tell Nia he had done it, and she found out only when a satisfaction of lien notice arrived in the mail addressed to her directly. The first piece of paperwork in this entire ordeal that had ever come with nothing attached for her to sign. He kept one habit from his father's house, even after taking the title, leaving his shoes at the door of every home he entered, including the greenhouse office. A small enough gesture that Nia noticed it only after the 4th visit and never mentioned it, though she started leaving a mat by the door not long after. His mother, 3,900 miles away, still marked his birthday, the same way she always had. And this year, for the first time since his father died, June called her the day before to ask what time to expect the soup, and she asked him whether the woman from the greenhouse he had mentioned once in passing was the reason he sounded like himself again. What does it mean to inherit something nobody in your family ever wrote your name on properly, and to spend years building it anyway, one careful measurement at a time, until the paperwork finally has no choice but to catch up to what your hands already knew, long after the people who should have written it down in the first place are no longer there to see it happen?